Welcome to Unit 3, Work Legally and Ethically. This presentation has three parts: legal requirements, that's legal requirements of your role, organisation requirements of your role, and ethical requirements of your role. For the assessments, 3.1 are written questions, 3.2 are scenarios dealing with unethical behaviour, 3.3 is a case study, a review of two policies or procedures. So let's consider this scenario. You're a boarding supervisor at a large co-ed boarding school and you've just witnessed this incident in the boarders' dining area. Dinner was about to commence and everyone was waiting for Year 8 student Hayley to sit down so they could start dinner. Hayley just stood there defiantly and refused to sit. Housemaster John put his hands on her shoulders and pushed her down firmly into the chair. So let's look at this and ask ourselves, are John's actions a legal breach? Has he broken the law? Are John's actions a breach of the organisation or the employer's policies or code of conduct? Are John's actions an ethical breach, acting in a way that's inconsistent with what society typically thinks are good values? So let's just think about this. Is it a legal breach? You could say it's assault, some sort of assault, but that's possibly a bit of a stretch. You could say that it's a breach of the organisation or the employer's policies or code of conduct, and I'm sure that it is a breach of those documents. You could also say it's an ethical breach, and I'm sure it is an ethical breach as well. So how, in your role, do you respond to John's actions? And, what defines your role and the scopes or the limit of your role? All of us are going to have a role description document or a job description document provided by our employer or provided by the organisation, and this impacts on our work role. Also impacting on our work role are the legal requirements of our role, the organisation requirements or the employer requirements of our role, and society's ethical standards that also impact on our role. 3.1 Legal requirements. In Australia we generally have two types of laws: statutes. These are rules of laws which are codified, or they're in a kind of system or a code, and these are made by Parliament, by the lower and upper houses of Parliament. We also have common law, and this can be called judge-made law or precedent law as well, and these are generally uncodified and they're from previous court cases, and that'll help you answer question 3. So when we're looking at statutes, who can make statutes? The federal parliament can make statutes, and state and territory parliaments can make statutes. Going back in time, we know that in 1901 the Australian Constitution was enacted, and we became a federation of states, and we became one country. And the powers are distributed between the federal government and the states, those powers being the power to make laws. So in 1901, prior to 1901, we were six little colonies like that, and each one of those colonies, they interacted with England, and they were largely independent. But there was a drive from the people at the time to become one country because they realised that that was just going to be so much more effective, to have one defence force, one postal system, etc. Just made so much sense. And so there were these meetings all around Australia, or little conventions, and then Australians voted, and you can see here a notice for Western Australia, and in this notice, all the rest of Australia had voted already. They'd all said yes, and they're encouraging Western Australia to say yes. This man here, Henry Parkes, he drove this idea of becoming one country, and he was the leader. He was actually the Premier of New South Wales and one of the longest serving premiers, the longest serving Premier of New South Wales, and he drove this idea to become one country. So the federal government have exclusive power to make laws for trade and commerce, taxation, defence, external affairs, immigration and citizenship, and states and territories also have parallel powers. That means that the federal government and state and territory governments both make laws on health and education, and possibly some other things as well, but mainly health and education. The states and territories have got power to make laws in all matters not assigned to the federal government, and particularly things like law and order. And if there's any sort of inconsistency between federal law, territory laws, then federal laws prevail. We want to look at human rights, and let's have a look at the relationship between human needs and human rights. Human needs are seen as being located within an individual human being, while human rights are located between human beings, how they treat each other, the respect, etc. So that should help you with question 4. We want to look briefly at Australia and the United Nations. And so this is question 5. What has been Australia's role in the United Nations? Australia's had a very big role for a small country. We're a founding member of the United Nations. We had a prominent role in the negotiation of the United Nations Charter in 1945 and when one of 8 nations involved in drafting the Universal Declaration of Human Rights. The Universal Declaration of Human Rights contains 30 articles which describe the most fundamental rights and freedoms of people everywhere in the world, and that will help you answer question 6. We just want to have a quick look at those rights. This is a summary of them, very brief summary. Articles 1 and 2, there's 30 of them, affirm human dignity, equality and brotherhood. 3 to 11, the rights of the individual, the right to life, outlawing of slavery and torture, equality before the law, etc. 12 to 17 are the rights of individuals within a civil and political society, so freedom of movement, right to nationality, right to marry, have a family, etc. Articles 18 to 21 are about the spiritual and religious rights of individuals. Articles 22 to 27 are the social, economic and cultural rights of the individual, like the right to work, the right to rest, to have leisure, etc. Articles 28 to 30 talk about rights coming with obligations, and that none of these rights can be used to violate the spirit of the United Nations. Australia is party to 7 core international human rights treaties, which is, again, that's pretty significant. The International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Right, on the International Covenant on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment, the Convention on Rights of the Child, which is pretty important to us in our role in boarding, the Convention on Rights of Persons with Disabilities. The Australian government enacts legislation to help Australia meet those international treaties. In the workplace, human rights are protected by legislation, but also in things like codes of practice or codes of conduct and workplace policies and procedures. So that should help you with question 7. We want to look at laws that affect your role. And so we're going to look at these specific areas: workplace, children, how we treat others, information, buildings and land, and copyright. The main piece of legislation for the workplace is the Fair Work Act 2009, and this governs the employee-employer relationship in Australia, provides a safety net of minimum entitlements, enables flexible working arrangements, etc. And this will help you with question 8. Under that Fair Work Act, we have legislation about workplace bullying and harassment. A worker or group of workers is bullied at work if a person or group of people repeatedly act unreasonably towards them and this behaviour creates a risk to health and safety. And you can see there the sort of things that are unreasonable behaviour, you know, victimising, humiliating, etc. Also, part of the Fair Work Act is workplace discrimination. Unlawful workplace discrimination occurs when an employer takes adverse action against a person who is an employee or a prospective employee because of race, colour, sex, sexual orientation, age, physical or mental ability or disability, marital status, family or carer responsibilities, pregnancy, religion, political opinion, national extraction or social origin. In the workplace, we also have the Workplace Gender Equality Act, and this resulted in the creation of the Workplace Gender Equality Agency, which is an Australian government statutory body that works to promote and improve gender equality in Australian workplaces. We have the Superannuation Guarantee Act to ensure that most employees receive superannuation support from their employer. And we have workplace health and safety. There is a National Model Act and a national body called Safe Work Australia. Safe Work Australia is mostly a policy maker, but then each state and territory also has a regulatory body that implements, regulates and enforces workplace health and safety laws. And that will help you with question 11, which says, what is the national framework for workplace health and safety? And then secondly, what is the state and territory framework for workplace health and safety, or how do they, you know, manage workplace health and safety? And you can see the different state bodies here. We want to look at workplace disclosure, and this is quite interesting because there's no legal obligation for an employee to disclose any disability or illness unless it might reasonably be expected to impact their ability to perform the requirements of their job. So there's no obligation for them to disclose a disability or illness unless it's going to impact their ability to perform their job. And that's the answer to question 12. Employees with physical injuries or disabilities involved in labour-intensive positions may harm their chances of a successful work cover claim if they fail to disclose those conditions. So, you know, that's something that people should think about. With mental illness, disclosure will only be considered reasonable when the condition might foreseeably put the safety of them or people they're working with at risk. Okay, so that's for question 12. Now we're going to move on to the second part of this child protection. First of all, we looked at employment or the workplace. Now we're looking at child protection, and we're looking at mandatory reporting. Mandatory reporting is a legal requirement for selected groups of people to report suspected child abuse and neglect to the government authorities. That it will help you with question 13. Mandatory reporting legislation is contained in the child protection legislation for each state or territory. South Australia has an additional act, and Queensland has an education act which also impacts child protection. And there is Commonwealth legislation that has mandatory reporting legislation for people associated with the court. And here you can see the different child protection acts for each state and territory. The next part of this is about how we treat others. In Australia, it's unlawful to discriminate on the basis of a number of protected attributes, including age, disability, race, sex, intersex status, gender identity, and sexual orientation. Now, we did this already in the workplace section, but this is not necessarily in the workplace, but generally in Australia, that it's unlawful to discriminate on the basis of those things. There are some acts, you can see them here: the Age Discrimination Act, Disability Discrimination Act, the Racial Discrimination Act, Sex Discrimination Act and Racial Hatred Act. And this asks you, question 14 asks you to list 4 of the discrimination acts that relate to discrimination. So you just need to list 4 of those. States and territories all have different anti-discrimination legislation and equal opportunity legislation. The next part of this is about information. So we've got two bits here, the Privacy Act and Freedom of Information Act. So the Privacy Act protects the privacy of individuals and regulates how Australian government agencies and other organisations handle personal information. The Privacy Act includes 13 privacy principles, and this will help you with question 15, but it is really important that you know your organisation's privacy policy and procedure, and that you follow that policy and procedure. Freedom of Information Act gives members of the public the right to access official documents of the Australian government and its agencies. The next section is about buildings and land. We have the National Construction Code, and with the National Construction Code, the different shire councils around Australia follow that and amend it to suit their particular areas, but there is one national code. And then for every state and territory, we have a fire safety organisation, and you can see them there. Then we have copyright. It's the last one of these sections, copyright. It's a right in certain creative work such as text, artistic work, music, programs, sound recordings, and these rights are granted exclusively to the copyright owner to reproduce the material, to sell the material, perform it, or whatever. So that's the Copyright Act. Criminal acts, such as assaulting or abusing a student, are generally state and territory laws. The Commonwealth Government has no general power to legislate in relation to crime. State and territory governments are mandated by their constitutions to legislate for peace, order, good government, etc. In their state or territory. So that's statutes, and now we just want to have a look at common law, and particularly we want to have a look at the duty of care, your duty of care to your students, and negligence. So negligence is a breach of duty of care. And one of the foundation cases, court cases in negligence occurred in about 1930 in Scotland, when a lady called Mrs. O'Donoghue was drinking a bottle of ginger beer in a restaurant with her friend, and there was a dead snail in the bottom of the ginger beer, and she got sick. And so she sued Mr. Stevenson, the maker of the ginger beer, and this went all the way to the High Court in London, and they found in Mrs. O'Donoghue's favour, they said that that Mr. Stevenson had been negligent, and I think he had to pay her something like £200, which in those days would have been a lot of money. So that is the basis of modern negligence law and duty of care, the way we understand duty of care today. That came pretty much all from that case, and of course it's been modified by many more court cases that have occurred since that time. Duty of care is a legal duty to protect students from risk of harm that reasonably should have been foreseen. And dignity of risk, I'm not sure if you've heard of this. Dignity of risk comes from the disability area, but it's the right of a person to take risks and to learn from mistakes. And there should be a balance between duty of care and dignity of risk. We've got to allow young people to, to take some reasonable risk, to learn from their mistakes, to experience different things. but at the same time we must ensure the safety of the young person. So that will help you with question 16 and 17. Sometimes you might become aware of a breach of legislation, somebody in your organisation that's broken the law. And so in your role, how should you respond? And there are some factors that we need to consider. Firstly, the person who has breached this law or broken this law and their position. So for example, if it's your head of boarding or your school principal, you're going to have to handle that quite differently, because normally you would probably fill out an incident report and then put that into your head of boarding or your principal. So this is a factor that is going to affect how you deal with a breach of legislation. Also the seriousness of the breach, how serious is it, and the scope of your role. Does your role include dealing with that sort of thing?
There may be situations where you need legal advice. Specialist legal advice might be necessary in situations where legal issues involved are complex or require specific knowledge. Situations where a supervisor or manager might need legal advice include complex legal matters, industry-specific regulations, litigation and disputes, criminal charges, family law issues, and employment law. And the rule of thumb is that if you're unsure about a legal issue, if you're unsure whether you need legal advice or not, it's better to err on the side of caution and seek advice. There are insurances that protect employees, like public liability, workers' compensation, and professional indemnity. Public liability addresses claims from third party for bodily injury or property damage that occurs in connection with your work, with your business operations. Workers' compensation insurance is designed to cover medical expenses and lost wages for employees who are injured or become ill as a result of their work. Professional indemnity protects professionals from claims of negligence or errors or omissions in the provision of their services. Mostly professional indemnity would be for managers or heads of boarding.
Question 19 says, if you became aware that another boarding supervisor had consistently been using your organisation's fuel card to fuel their own vehicle, how would you respond? How would you report and record? And in your answer, you should be referring to your organisation's policies and procedures. What policies and procedures there are around reporting this sort of thing. How you're going to document it. You're going to use an incident report, or how are you going to document this, and then how will you report that. So that's the end of section 3.1. 3.2, employer requirements or organisation requirements. Organisation documents include vision and mission statements, policy framework, policies and procedures, code of conduct, code of practice, and various other documents. So let's have a look at policy framework. What is a policy framework? The policy framework describes the whole process for developing policies, procedures, guidelines, protocols, and documents such as instructions for the organisation. The policy framework defines the principles, the principles behind the policies and procedures, the scope of the policies and procedures, what do they cover, who's involved, etc., and the life cycle. How long is this policy in place before it is reviewed? That sort of thing. So that's the answer for question 20. What is a policy framework? Question 21 asks, what is the purpose of a policy framework? So a policy framework is designed to enable compliance with different laws and regulations, clear and consistent governance or management, efficient and effective decision making, and accountability and authority for individual roles and groups. So that will help you with question 21. Policy framework scope describes the different people or positions within the organisation that the policy framework covers. You can see here there's a diagram of what is typically covered within a policy framework. Then we go on to policies. How do we define a policy? A policy is a statement of principles or position that's intended to direct the decision making and operation, and it supports the achievement of the organisation's vision and objectives, their vision and mission. Policies have a long-term focus. Policies form the foundation of the governance process and the basis of a quality system, for your organisation. So that will help you with question 22. What is the purpose of policies? This is question 23. The purpose of a policy is to support the achievement of quality outcomes in your organisation, to address compliance with laws and other obligations, to reduce institutional risk, by having standards and internal controls, that sort of thing. Question 24 asks, what is the definition of a procedure? So a procedure addresses the processes and the actions that are aligned with a policy, solely, the operational steps that are required to implement the policy. Procedures will provide clear instruction on the way policy will be implemented. They'll have steps through all the actions required to implement policy principles. They'll give responsibilities, or they'll align responsibilities to different people in the organisation, and they will enable monitoring of policy implementation. Question 25 says, why should staff be involved in the development and the review of policies and procedures? Policies and procedures are living documents that grow and adapt with the organisation. Boarding staff that are affected by a policy or procedure should be involved in the development or the review of policies and procedures, because this gives them a sense of ownership. It also means that boarding staff are familiar with the policies and processes, the procedures. They know and understand them, they're familiar with them. Policy and review and revision is a crucial part of an effective policy and procedure management plan, because different things may have changed, like legislation or laws. Your practice may have changed or evolved, or there might be new practice, that sort of thing. There might be new and better procedures available. So it's important to have a review process where policies and procedures are reviewed on a regular basis. Policy review is best if it is done regularly and proactively, if it's built into the organisational calendar, so like there's a plan for policy review and revision, with every policy reviewed every 1 to 3 years. And so I know that's a big ask for some organisations. There's a lot of policies and procedures in boarding, but that is the best procedure, to have a plan where they're reviewed regularly and at least every 3 years. All right, so this next section here looks at codes of conduct and codes of practice. And, what's the difference between a code of conduct and a code of practice? A code of conduct is a set of guides that recommend voluntary actions that staff members are advised to follow. So you're advised to follow this code of conduct. A code of practice is much more rigorous because the guides are mandates. To comply with the code of practice, you must follow exactly what is set down within the code. There's no sort of interpretation of it. You must follow exactly what's set down. When an organisation develops a code of practice, it has a lot more detail than a code of conduct, and it must be followed exactly. So I hope that explains the difference between a code of conduct and a code of practice. Let's talk about standards. There are no mandated standards for boarding in Australia. However, there is a boarding standard for Australian schools and residents that was developed in 2015 through a consultative process. It's not mandated, but most boarding providers are aware of the standard and they're working towards being compliant against the standard. Non-government schools in Australia go through a registration process, generally every 3 to 4 to 5 years, and this is carried out by the state or territory government organisation that manages non-government schools, and some of these registration processes have required standards for boarding, and we're seeing that this is increasing. You know, there's a increasing emphasis on standards in these registration processes. So that will help you with question 28. All right, let's have a look at managing complaints. So, and you know, all organisations get complaints from time to time, and we need to have a process for managing these. So when somebody makes a complaint, we need to acknowledge this with empathy. You know, to have empathy for their position. Don't accept or deny blame. Pass them on to the correct person to deal with the complaint. Ensure confidentiality. Explain how the complaint must be presented. Is it presented in writing? Do you do them online? Can you just present them verbally? That sort of thing. When will the complaint be resolved? How do they get progress on the complaint? And what to do if they're not satisfied. The next part of the complaint management process is investigating the actual issue or what the person's complained about. So you need to do things like identify witnesses, hear both sides, interview both sides, make sure that staff members and students have got support during this investigation process. Then you have the feedback to the parents. If the parents or whoever made the complaint is not happy with the outcome, they should have some sort of avenue for further action. And this is generally described in the complaints procedure. Most often they would refer the matter to the governing body. We should see complaints as an opportunity to improve practice. I know that sometimes we can find complaints disappointing and upsetting, but we shouldn't be defensive. We should see complaints as a way that we can improve our practice. And if we deal with complaints well, the outcomes can be very positive. And I know that in my own experience, I had a parent who complained about something that happened in the school where I was principal. We didn't agree with what the parent was saying, but we worked with the parent. And in time, that parent became one of our strongest supporters. So the outcomes can be very positive. It's important to log complaints, to keep a record of all complaints and their outcomes, and an official complaints process or forms are much more professional than scraps of paper. And I know that most organisations these days will have a data entry system, online data entry system where you can record complaints or keep a log of complaints. You would keep that record in the individual staff or student files as well. Sometimes these complaints can develop into legal issues, so we should make sure that they're professionally presented, that they're accurate and complete. So that will help you with question 29. We want to look at informed consent. What is informed consent? And you know that this comes from the medical field initially, but it means consenting to something after being advised of and understanding all of the risks involved. And this will help you with question 30. So parents will need to give informed consent for their child to have medical procedures or for them to go on an excursion or some sort of high-risk activity. So that's where we see informed consent in boarding and in other places as well, of course. We want to look at records management. We want to make sure that our records are secure, that they're protected, that they're easily accessed and updated as required, and they're only accessed by people who have permission and reason to have access to them. More and more these days, records are digital copies are stored digitally, and there's lots of options for doing that, but we can also have hard copies. So secure storage of documents, if it's a hard copy, that would be a locked storage cabinet, like a filing cabinet, and these would be reviewed and archived as required. And if they're digital, they'd be backed up. Usually this is by cloud technology these days. They'd be password protected and again reviewed and archived as required. And this will help you with question 31. And that is the end of section 3.2. Thank you. 3.3, ethical requirements of your role. So what's ethical and what's legal? A legal issue always has a law behind the issue. If something's unethical, it means not conforming to the approved standards of social or professional behaviour. And some activities might be legal but not ethical, and some might be ethical but not legal. So I hope that helps you with question 32. For legal and ethical issues in boarding, the law process will deal with serious illegal activities. The residential organisation will decide how it deals with unethical behaviour and minor illegal activity. So for example, if somebody took the milk out of the fridge when they shouldn't have, it's probably illegal, but it's quite minor. The professional code of conduct will cover ethical issues and some legal areas as well. So so that's the legal and ethical issues in boarding. Ethical issues include privacy, confidentiality, staff to student boundaries, and that's a very important ethical issue, ethical area. Students' rights, like equal opportunities, non-discrimination, etc. Cooperation, collaboration, financial dealings, integrity and honesty are all ethical issues that we will come up with in boarding. Ethical responsibilities that apply to our work role can be found in organisation documents such as Code of Conduct. So that's going to be the primary document that describes ethical behaviour or ethical responsibilities, but also in specific policies and procedures. So your use of electronic media, that sort of thing, those policies and procedures will also describe ethical responsibilities and conduct. It might also be in your duty statement, your contract of employment, and also in the staff handbook. There are also ethical standards that are part of a society code of behaviour that are just known and accepted. You know, that these are ethical standards and this is just how we behave. And it concerns things like lying, stealing, that sort of thing. Those sort of ethical standards that are just known. They may not be written in your code of conduct, but they're known and accepted by society. Staff should be aware of their own values and attitudes, and they should understand how these might affect work practice. So being aware of our own personal values, attitudes, the things that are important to us help to ensure non-judgmental practice. This will help you with question 34A. Staff should also make sure that they have a professional development plan or a professional development process so that they make sure that their practice is up to date, that's relevant, and that it's consistent with what people are doing these days. All right, so I just want to look very briefly at Assessment 3.2. Assessment 3.2 are scenarios. So that's a group of different scenarios. And for each of these scenarios, we have to decide, has a breach of legislation, has somebody broken the law, or is it a breach of ethics, or is it both? And then what is the relevant law or ethical issue? And then what should you do as a residential supervisor in the same residence? What should your actions look like? Is there a workplace procedure to follow? When we are responding, when we're working out what we should do, the first thing we should always do is to make sure that the students involved are okay. So if it involves a student, if somehow a student has been harmed, we need to provide care and support for that student in the first place. We need to make sure that our facts are correct and, to document our facts. We should talk to other staff members if possible and report to management if this needs to be reported to management. Most of these scenarios will need to be reported to the head of boarding. I just want to talk briefly about reporting externally, so reporting outside your organisation. There's no assessment questions on this, but I think it's an important thing to talk about. We should exercise great care before reporting student incidents or ethical issues to any bodies outside the organisation. So that could be to, it could be to a newspaper, it could be to a media source, it could be to an ombudsman or somebody like that. If we do this, it can make the problem a lot larger. It may damage other staff members and students, and you can burn your bridges in this industry that we work in. So what we suggest is this: unless a situation involves real and immediate harm to a student, then give your management an opportunity to hear your concerns and to rectify the situation. So work up through your chain of command. Don't ever threaten the organisation. And the most common threat that we hear is people will say, look, if you can't do this or if you can't do that, then I'm going to leave. Organisations probably really value people. They don't want you to leave, but they don't like being threatened. So just present our views calmly and professionally, and make sure that our goal is to care for the students and improve the boarding situation. Sadly, mostly these situations are around entitlements, remuneration entitlements, rosters, those sort of things, which affect boarding staff, and they're unhappy with their organisation, and therefore they report outside. You must report some things, and that's any issues mandated by legislation, like mandatory reporting, or if there's issues in your policies which must be reported to management. We think it's always good to take advice, and I think all of us have got wise people in our lives. If you take advice, this can provide a different perspective on an issue, and the person who you're talking to might be able to provide additional information. We need to be careful here that we don't breach confidentiality, but I think we can do this by asking more general questions. Another option, of course, is to resign. If you're not going to report and you can't live with the practice, you probably should consider resigning, and that's often better than being constantly unhappy at work. And I think if you did do this, if you took that option to resign and to look for another boarding position, to go out in a positive way, to thank the organisation for the opportunity to work for them, and just to leave in a positive way is important. One day you might want to come back. All organisations have a staff grievance procedure for dealing with grievances or complaints, and you should follow these processes correctly and professionally. And for example, this dispute resolution in the staff handbook, I'm hoping that your staff handbook would have a dispute resolution process in it. Unethical conduct by fellow workers. Discovering unethical behaviour amongst co-workers tests our own values and our own ethical behaviour. It can be, very difficult. It can put a lot of pressure on us, and it can be difficult to decide what to do. It is really good if your organisation has a policy for unethical behaviour. Having a clear policy that's read and signed by each employee helps people decide what to do after witnessing unethical behaviour. The policy should give a clear outline of what's expected of the person reporting. It should include who to contact and how to go about it. It should clearly state the repercussions of unethical behaviour and have a fair process for staff. It should provide support during an investigation process. This is to help you with question 35. How would you respond to a possible ethical breach by a fellow worker? Make sure that we check facts, don't just assume things. Listen to their story if you get an opportunity to talk to them about it. Work out whether you're going to report or not to report, who you report to, do you document it, those sort of things. Ethical areas can be very grey areas, so it's good to have an ethical decision-making process. This is where we recognise an issue, where we check information and evidence, consult with somebody, evaluate our options, come to a decision that's consistent with policies and procedures, and then reflect on that decision. So everybody should have some sort of ethical decision-making process.
Next, we want to talk about conflict of interest. Now, it's not wrong to have a conflict of interest, and it happens to all of us at different times. A conflict of interest is when an employee could gain a personal benefit or advantage from an action or a decision they make in their work role. And some examples include: a supervisor is related to a student, a decision is to be made about the student being captain or receiving an award, so it's a potential conflict of interest. The head of boarding employs family members as supervisors and is responsible for their pay, conditions and performance. The head of boarding has a financial interest in a local mechanical workshop, and he chooses that workshop to service all the residents' vehicles. So all of these are potential conflict of interest. So how do we deal with them? Good practice with conflict of interest is to let people know of the decision required, declare your conflict of interest, you're being transparent and not trying to hide it, and then don't make any of the decisions in that area. So keep an arm's length away from it. Ask an impartial person to make a decision. So in that last example, where a head of boarding or a school principal has a family member who owns a mechanical workshop, that happened in my work. And so what I did was that I asked somebody else to make all the decisions regarding the servicing of the buses, the servicing of school vehicles. And that meant that they could take them to my relative or they could take them to somewhere else. It was entirely up to them, and I never got involved in the decisions. So that's called keeping an arm's length from those decisions. It's good practice with a conflict of interest. Next, we want to talk about needs and rights. There's an expectation that the boarding environment will meet the needs of boarders. Parents have a right to a duty of care that will protect and nurture their children, and students have the right to be treated fairly and humanely with dignity and respect. So let's have a look at some of these. Let's have a look at students' rights. So here's some of them. Right to safety and equality, fair and respectful treatment, privacy and confidentiality, to make a complaint or to give feedback, and a positive resolution of an issue. Parents' rights include their child receiving appropriate care and nurture, to be informed of significant issues and information, to be able to inquire about their students' welfare, to make a complaint if they're not satisfied, and to have the complaint investigated in a timely and professional manner. So what about boarding supervisors' rights? And there's a lot more than these, but there's some here that are primary rights. And these are to be treated with courtesy and respect. I know it doesn't always happen, but we feel that that's a basic boarding supervisor right. That boarders comply with requests and instructions, and you're thinking, well, that doesn't always happen either. But it is a right that, if you instruct or request something from a boarder, that they do follow those instructions. To be treated fairly and respectfully by employers. Rosters are fair and allow sufficient rest. And then all of the conditions of the award, and you'll see these 10 minimum entitlements, like maximum weekly hours, request for flexible working arrangements, and so on. And so they're the 10 minimum entitlements. Next, we want to look at boundaries. Boarding staff relationships with young people are strictly professional. Professional boundaries protect boarding staff, and they also protect the young person, and we should maintain these with integrity. These protective guidelines support our role in the well-being of young people, and they enhance respectful relationships between students and adults. And you can see that book there, that manual, that comes from South Australia, but there's a manual like that in every state. They're worth reading. They're very clear about boundaries and protective guidelines, protective practice. When we look at boundaries, we're looking at boundaries in communication, physical contact, place, that's, your own place, and students going to where you live, targeting individual young people, your role and possessions, and particularly around things like cameras and phones, etc. With boundaries, It is a particular challenge to provide a home-like environment but not compromise the professional boundaries or not compromise the welfare of young people, because we have a relatively informal environment in boarding. We have caring relationships. Students can receive respectful guidance and support, but we need to keep those professional boundaries. When staff ignore boundaries, the consequences are severe. There's sometimes lifelong harm to young people. It undermines the professional reputation of a boarding supervisor. It damages the confidence of the community and the residents, and there can be disciplinary action from employer or regulating authority or even the courts. So working one-to-one with young people, firstly we need to note that this is a professional relationship. It is not personal. So it's a professional relationship, and we did this in BF2. And there's 4 little rules to help us remember this. Firstly, make it public. So when you're working one-to-one with a young person, make it public in a visible location. Use residents' IT systems like video systems, and not in personal emails, Facebook or texts. So Facebook Messenger or texts. Make it authorised so that you've got the guardian's consent or the resident's consent. Make it timely, working hours, and brief as necessary, and make it purposeful. There must be a reason for this one-to-one interaction with a young person. So there are 4 little rules that help us in maintaining those professional relationships and maintaining our boundaries. Now, the last part of this assessment is a matrix, and when you look at it, it's quite big and quite involved, but it's quite simple to do. And so we're just going to go through it quickly because, when we start to go through it, you'll see that it's quite logical. So these are the legal and ethical considerations, how they're applied in a work context, and what are the consequences of breaches. So these 3 columns, the first column looks at the legal and ethical consideration, how it's applied in the organisation, and consequences of breaches. So first, the care of children. So we have ethical boundaries in a code of conduct and duty of care, and the consequences of breaches are harm to children and possible legal action. And you probably realise that there are more consequences than just this, and there are probably more ways that this is applied in the organisation. So if you wish to, you can write down additional comments here, but these will be all you require to do this assessment. Mandatory reporting. So how it's applied in the organisation. Safe to work with children's checks, and that's different for every state. Police checks and mandatory reporting policy. Consequences of breaches, possible fines and legal action, loss of employment, and ongoing harm to children. Disclosure. How it's applied in the organisation is code of conduct, organisation policies and procedures, induction and training. Consequences of breaches are loss of trust, possible harm to the student, and possible loss of job. The next of these is practitioner-client boundaries, and we were just talking about boundaries. So how it's applied in the organisation, organisation code of conduct, induction and training. Consequences of breaches are loss of trust, possible loss of job, and possible legal action. And you can see that some of these are repeated over and over. Duty of care. It's a standard of care policy and procedure, and also induction and training. Consequences of the breach is harm to a student, possible loss of a job, possible legal action. Dignity of risk, and it's applied in an organisation through staff induction and training. The consequence of a breach is a reduced quality of life for students. So the next one of these is discrimination. It's applied in the organisation through a code of conduct, organisation policies and procedures. Consequences of breaches include harm to a client or harm to a student, possible loss of job, possible legal action. Privacy. It's applied in the organisation through code of conduct, organisation policies and procedures, and induction and training. Consequences of breaches are harm to the client, possible loss of job, and possible legal action. Confidentiality. It's applied in the organisation through code of conduct, organisation policies and procedures, and induction and training. And the consequences of breaches are harm to the client, possible loss of job, and possible legal action. The next of these is informed consent. It's applied in the organisation through code of conduct, organisation policies and procedures, and induction and training. Consequences are possible harm to the student, possible loss of job, harm to the organisation reputation. Codes of conduct document, consequences of breaches are harm to the client, possible loss of job, possible legal action. Codes of practice. We don't have these very often in boarding, but you could have a code of practice document, and the consequence of a breach is harm to a client, possible loss of job, and possible legal action. We're coming to the end of these. So practice and standards, how it's applied in the organisation, codes of practice, codes of conduct, organisation policies and procedures, and induction and training. And you probably realise that we do have a standard for boarding, the 2015 boarding standard, but we don't often have codes of practice. What are the consequences of breaches? Possible harm to the student, possible loss of job, harm to the organisation reputation. Human rights. These are applied through code of practice, code of conduct, organisation policies and procedures, induction and training. Consequences are similar. Possible harm to the student, possible loss of job, harm to the organisation reputation. Complaints management. These are applied through complaints policy and procedure, and consequences of breaches are possible harm to client and organisation, harm to organisation reputation. Then we have records management, and so these are applied in office processes and codes of practice where we have them. Consequences of breaches are possible harm to the student and the organisation, disorganised and incomplete records, which then adds to harm to both the student and the organisation. Policy frameworks, so these are applied in a policy framework, policy and procedure, and if you don't have these, you have disorganised policy and disorganised procedure. So that's policy frameworks. Continuing professional education, that's part of what you're doing by doing this course. So professional development or professional learning, the consequences of a breach of this are reduced care standard for the student. And this is the last page. So the legal and ethical consideration is work health and safety. It's applied through work health and safety policy and procedure or policy and practice. The consequences of breaches are possible harm to the worker, the student and others, possible loss of job or legal action, work role boundaries, responsibilities and limitations. And so that's knowing what are the limitations on your work role and knowing the boundaries, etc. So it's a work role document or whatever your organisation has for you, a job description or a practice description, organisation policies and procedures, and induction and training. You can see how a lot of this comes in through induction and training. The consequences of breaches are possible harm to the worker, client and others, possible loss of job, and possible legal action. Now, the last one of these are industrial relations legislation. So we see this in the codes of conduct, role descriptions, workplace health and safety policies and procedures. And the consequences of breaches are possible harm to the student and the organisation and harm to organisation regulation. So we've got through all of those and we've come to the end of Unit 3. Thank you very much.